third important instrument is the role in the instrument on hazardous waste management. So the context in which we discuss about hazardous waste management is the rapid industrialization, increased use of chemicals and rise of chemical industries. So this has led to a huge generation of hazardous wastes, and then that brings us the context for an eco-friendly management and disposal of hazardous wastes. The legal responses in this context has been Hazardous Wastes Management and Handling Rules 1989, and this was later on modified in 2008. Now that we have a new document called Hazardous Waste Management, Handling and Transboundary Movement Rules 2000. A significant difference of this 2008 instrument when compared to 1989 instrument is that this is a comprehensive instrument which covers both the domestic aspects of hazardous waste management as well as the transboundary movement of hazardous waste management. I mean, the rationale behind this rule is, again, I mean, to protect health and environment from this menace of hazardous waste. So one important aspect of hazardous waste management rules 2008 is that it does not deal with wastewater, municipal solid wastes, radioactive wastes and bio-wastes. I mean, the reason is quite clear, because as far as these wastes are concerned, there are separate instruments in existence. And it talks about, I mean, hazardous waste management rules entrust the responsibility for eco-friendly management of hazardous waste with occupiers. That means, I mean, it casts duty upon the producers of hazardous wastes to manage, to establish a mechanism, whether through themselves or to entrust it to another individual or company having sufficient mechanism for hazardous waste management and disposal. Another important aspect of the hazardous waste management rule is prevention of accidents, because it says that all occupiers, I mean, it casts a duty upon all these, for example, industries, a duty to take all adequate steps to prevent accidents and limit their consequences on human beings and environment. And similarly, safety of workers is an important aspect addressed under this. Another major aspect addressed under this rule is transboundary movement, and in the case of transboundary movement, an important part is the Basel Convention on transboundary movement of hazardous waste and its disposal. Here the nodal ministry is Ministry of Environment and Forest, and the key regulatory part is that prohibition of import. I mean this document, this legal instrument prohibits import of hazardous wastes from any country to India for disposal. That means there can't be import of hazardous wastes to India for disposal. Import of hazardous wastes to India is permitted only in exceptional circumstances where the import of hazardous waste is for recycling or recovery or reuse. Similarly, export of hazardous waste to any other country is also prohibited unless this is for reuse or disposal. In both this export and import context, prior informed consent is mandatory. In case there is import or export import or export happens by violating the rules, the consequences is such import. For example, if there is a hazardous waste import to India without getting prior informed consent from the nodal ministry, such imports are liable to be re-exported. Liability is a crucial aspect covered under the hazardous waste management rule, because it says that the occupier, importer, transporter and or operator of a facility is liable for all damages caused to the environment and third party. So this means it says that due to if such damages are caused due to improper handling of hazardous wastes or disposal of hazardous wastes. This seems to indicate that this hazardous waste management rule is fixing liability on the basis of fault. This needs to be contrasted with some of the developments initiated under the auspices of the Supreme Court of India, that is the concept of absolute liability, where the Supreme Court in the oleum gas leak case in 1986 supported or introduced this idea of absolute liability, in cases of industrial accidents that involves hazardous wastes. There seems to be a contrast between this absolute liability as introduced by the Supreme Court in the oleum gas leak case and this fault based liability that seems to be the case as prescribed under the hazardous waste management rules. Now briefly let's broadly take a mapping of state level laws, which I already have mentioned, that the PRI Panchayati Raj institution laws and the law relating to urban local bodies that cast responsibility on the local bodies to have a proper mechanism for the management of hazardous wastes. When we look at this issue, there is this duty is not just a statutory duty emanating from law relating to Panchayati Raj institutions or urban local bodies. Instead, this is also a constitutional duty that emanates both from Article 21, the right to life, as well as from directive principles of state policy. There are quite a few interesting cases or pertinent or relevant cases in this context. For example, in the case of Municipal Council Ratlam versus Vardhichand, where the Supreme Court said that it is a statutory duty of the urban local bodies or the local bodies in general, and non-availability of fund cannot be taken as an excuse for non-fulfillment of such duties. Similarly, in BL Vadhera case, the court endorsed this idea or endorsed this this point that there is a constitutional duty upon the government to have proper mechanism for waste management that derives from its duty under Article 27 to take adequate steps for the improvement of public health. And the last point in this module that is a case study of shipbreaking that is pertinent in the context of hazardous wastes. Shipbreaking in India has been a major source of foreign currency, and another important reason why it was sustained, because it provides significant quantity of steel to the Indian economy, and it also provides direct and indirect employment to huge number of people. This was the major reason why this shipbreaking industry was sustained in India. At the same time, this poses significant threat to human health and environment, and this also needs to be examined in the context of large number of ships being brought into India from outside, and therefore Basel Convention on Control of Transboundary Movement of Hazardous Waste and Disposal is also pertinent in this context, where India is a party to this convention. There has been several controversial issues in the context of shipbreaking. For example, Clemenceau in 2006, where a German ship came to India for disposal, and Blue Lady case in 2006 again. There's recently Exxon Valdez case in 2012. We are not discussing all these cases in separate. Instead, we will try to understand what happened in these cases, and what has been the approach of the Supreme Court in all these cases. To summarize the approach of the Supreme Court, the court's approach has always been overwhelmingly focusing on the economic advantage of shipbreaking industry in India. And to put in a different that means it resulted in undermining the impacts of shipbreaking industries on the public health and the environment. And the court also emphasized on the enormous quantity of steel to be recovered from the shipbreaking industry, and court also emphasized the employment benefits of shipbreaking industries. However, what we can conclude from these cases is that there is a question of weighing or striking a proper balance between the economic and the ecological aspect of shipbreaking industry. In all these cases, whether it was Blue Lady or Exxon Valdez case, the Supreme Court seemed to have given more importance to the economic aspect of shipbreaking industries, and thereafter in all these cases court granted permission to proceed with shipbreaking processes. And this it's pertinent to note that the court recognized or court granted permission despite there was enough reports from non-governmental organizations highlighting the serious adverse implications on health and environment. So to summarize, what we have seen is that in India we have a number of legal instruments that focuses on waste. As far as rules framed under the Environment Protection Act 1986 is concerned, the approach has been to have separate legal instruments addressing issues relating to different kind of wastes, say for example municipal solid waste or electronic waste. The key institutional mechanism is Central Pollution Control Board, State Pollution Control Board, and local bodies. And in addition to this, judiciary has played significant roles, whether one should agree with or not. For example, as far as adoption of municipal solid waste management rules are concerned, the Supreme Court has played significant role. But however, in the case of shipbreaking industries, the critique is that the Supreme Court has, the judiciary has aligned with or weighed or gave more importance to the economic aspects of shipbreaking industries and undermined the ecological or the environmental aspects and public health aspects of the shipbreaking industries. So to end, the key challenges in this context is we have enough number of rules, enough number of legal instruments, but the implementation apparently continues to be a key challenge. And another major important part is the control of generation of wastes. It is good that we are focusing on collection and transportation and disposal and recycling and reuse of wastes. However, the generation of wastes needs to be also focused, and this might require a significant change in the mode of production and consumption we are following right now, because unless and until we change our mode of production and consumption or production and consumption patterns, and we will continue to generate more and more wastes, and then waste management will continue to be a key challenge. Thank you.